Good day, doctor. We are from Group 3, and our law firm name was Alys Co. And we have Science, Ting, Lawyer Ting, and me, Law Sing, and Angeline. And we will conduct a legal review on a movie from United States or Americans based on the family topic on nullity of marriage. And our movies was started on 1984. And we will play a trailer of our movie for doctor to have a look on our movie. And this movie was considered as a polygamy practice by a non-Muslim. And we have first wife, which is known as Nikki, and the second wife, which is known as Maudie, and also Rob. Rob in this movie have practiced the polygamous marriage with the first wife, Nikki, and the second wife, Maudie. And Rob is the person who looking forward to become a father. And however, her first wife, Nikki, was a solicitor and she lives a busy lifestyle and almost have no time to raise a baby with Rob. And because of this issue, they have a lot of arguments and quarrels all the times. And one day, Rob had met Maudie during the interview for a report, and Maudie was a cyst. And the problem here is the Mickey and Maudie get pregnant at the same time. Because of that, Rob doesn't want to hurt the first wife, Mickey, and has entered a second marriage with Maudie. And the focus of our assignment 3 is that Rob here has made an offense of bigamy and have practiced polygamous marriage, which is prohibited according to Law Reform Act 1976 in Malaysia. So there are issues from our movie, Nikki and Maudie, whether the polygamy marriage entered by Rob as non-Muslim man with the second affair, Maudie, can be considered as valid or void marriage according to the provisions of Law Reform Marriage and Divorce Act 1976. So this will be provided but supported by our provisions and principles in our Law Reform Act towards the nullity of marriage between Rob and Maudie in this movie. And basically, according to Section 69 of the Law Reform Act, where a non-Muslim had entered a second marriage during the succeeding marriage, which is known as polygamy practice among non-Muslims, was prohibited and not valid. So in this movie, Rob still have not divorced with the first wife, Nikki, and their marriage is still valid according to law. So Rob cannot enter a second marriage with Maudie, and the effect of that is void under Section 6 of the Law Reform Act. So Rob marriage with Maudie shall be void and basically known as no effect at all. And here, Rob also can be charged for the offense of bigamy by the first wife, Nikki, under Section 494 of the Penal Code. This is stated under Section 7 of the Law Reform Act.
Hi everyone, my name is CHONG, entry number 271232. Now moving to the discussion and legal comment part. Polygamy marriage among non-Muslims after the appointed date will considered as void for the second marriage. The man who practiced the polygamy marriage will be charged for bigamy under Section 494 of the Penal Code, no matter the second marriage was made inside or outside Malaysia during the succeeding of a married marriage. In fact, there was an amendment after the case of Public Prosecutor vs. Rajaban. In this case, the respondent was married with the petitioner in India. They registered their marriage in Malaysia when they moved to here. The respondent visited to India again and married with another woman when the first marriage with the petitioner still succeeded. After that, the respondent brought the woman back to Malaysia and resided. Hence, the respondent was charged with the offence of bigamy under Section 494 of the Penal Code for the second marriage. The court held that it had no jurisdiction to hear and try the case because the act of bigamy was committed outside Malaysia. Section 5, 6, and 7 of LRA prior to the amendment can support this. Section 5 did not apply to second marriage which contracted outside Malaysia prior to the amendment, but its scope have been extended after the amendment. Applying to the movie, if Rob registered his marriage in Malaysia, then his second marriage with Maldi will be considered as void. He will be charged for the offence of bigamy for his second marriage, even though it takes place outside Malaysia by the virtue of Section 5, 6, and 7 of LRA.
My name is Angeline, metric number 272069. Okay, under customary law, if the Rob conducted the marriage under a customary law which recognized the polygamous marriage prior to the appointed day of LRA, he will not be deemed to commit an offence under Section 7. The validity of such marriage will be secure regardless of its illegality at the current law, as Section 4, subsection 1 of the LRA states that the marriage solemnized before the appointed date will not be affected by the other provision in this act. So, Rob will be allowed to marry Maudi legally even he had not divorced Mickey, and their marriage was still subsisting as the practice of polygamy was acceptable under the customary law. In the case of Kausalya versus the legal representative of Jamuna, the plaintiff claimed themselves to be the lawful children of the deceased, as their mother had contracted a valid marriage with the deceased and wished to be included in the list of beneficiaries to the estate of the deceased. The defendants rejected them and contended that the marriage between the plaintiff mother with the deceased was void, as the Hindu law only recognized monogamous marriage and the plaintiff were not the legitimate children of the deceased. The plaintiff relied on the report of the Royal Commission on Non-Muslim Marriage and Divorce Law dated 15 November 1971 and argued that Hindu law recognized polygamous marriage. The trial judge dismissed the plaintiff's claim on the ground that the Hindu law did not recognize polygamous marriage. However, the decision was overruled by the Court of Appeal. The learned judge referred to the cases decided by the Indian Supreme Court and held that since the solemnization of the marriage was held before the appointed date of the LRA, it was a valid marriage, as the ancient Hindu law, which recognized a polygamous marriage, had the same position in Malaysia at the material time. So, it can be seen that from this case, the problem began to arise when the polygamous marriage, which was used to be legal before the appointed date of the LRA, but become illegal after that. Since the interpretation of law by one court may be different from other, the issue regarding polygamous marriage conducted before the appointed date and the issue derived from that marriage are uncertain, and slightly distinction of a case with another similar cases may be lead to a contrasting result.
Now I will discuss the remedy that can be sought for the amount in this type of marriage, which is the decrease of purity. So although the law is the ignorant party who did not know that Rob has an existing marriage with the Mickey. However, this marriage also void ab initio, as is against the foundation belief of the monogamous marriage in Section 5, Subsection 1 and Section 6 of the LRA. This is because one of the elements of marriage, which is the capacity, has been seen. As long as a civil marriage man cannot enter into another civil marriage when the first marriage still subsisting. Thus, is more redress the fact other words, she can apply a decree of nullity which will be pronounced as an effect of a new marriage if the court is satisfied that there is a polygamy marriage practiced by the law. According to the Section 73 of the LIA. So this is a type of declaration through a legal procedure that aims to establish that there was a never valid marriage that place in the eye of the law and release the innocent party, which is the law, from the void marriage. As the law is the innocent party, as she did not know the fact that the Lord had committed bigamy with the relief of his falsehood. So we can see in the case of wisdom against wisdom, where the respondent already married in 1962, but subsequently entered another marriage in 1973 in England with the applicant who was unaware of the marriage status of her. The court granted a decree of nullity and held that the marriage between applicant and respondent after the succeeding marriage is a practice of polygamy marriage, irrespective of the ignorance of the third party towards the existence of the very marriage between the first and the second party to the marriage. So, more can apply the decree of nullity to annul the marriage between her and Rob. Besides, there is also another issue arise if the marriage is never be annulled, which is the property relation. As the mother has pregnant and after she born out her child stated also the big problem when it comes to the inheritance of the property. The void marriage causes the wife and the child cannot take any legal action to participate in the property relation between the Lord and his first wife, Nikki.
To sum up, our group has decided that polygamy marriage entered by Rob as a non-Muslim in this case with the second affair is considered as a white marriage under Section 5 of ALARE, which is not recognized polygamy marriage for non-Muslims. And we also have to note that Section 6, which also deals that polygamy marriage will be void as ab initio, as never existed before. And as we discussed before, Section 7 of LRA that states that polygamy marriage done by a non-Muslim can be charged as an offense, since Rob as a non-Muslim who practiced the polygamy act with his affair, Maude. So he can be charged under Section 494 of Penal Code. Then next we also have to note that Rob had practiced polygamy marriage. It will be considered as a legal if the act was done before the appointed date of LRA, as stated under Section 4 of LRA. And we also finally want to tell that once Maude get to know that Rob has practiced polygamy with her, she can apply for the nullity of marriage. However, as an innocent party, she also have to face the legal challenges regarding her child's status to the inheritance of the property of Rob, since her marriage will Rob never been in existence. So that's all from us. Thank you so much.